your eyes now, but I know there's always a way. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. The connections might be tangled, the power source has lost its spark, but every wire tells a story, and I can mend what's torn apart. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. When the current isn't flowing, when the signals disappear, I'll be here with tools and patience, make the static crystal clear. Every cable, every circuit, every problem that you bring, I'll restore what time has broken, make the whole world sing. So don't you worry about tomorrow, don't you stress about today. I've got maintenance for your troubles, and I'll chase them all away. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. Hey, Daniel, everything's good as new. Hey, Daniel, I'll fix you up for you.
Well, welcome to the show, everybody. It is Saturday, which is miscellaneous cases. And yes, Trin, I've had a good week. It's always busy on this channel. It's always busy. It's always something that needs to be done with the channel. It doesn't stop, you know. It doesn't stop. You have to go through and YouTube and get what you're going to talk about with certain judges, and it takes time to do all that. But I think I got enough material for a while. Today's miscellaneous cases. I do have a little Judge Fresh Hour that'll be coming up one day. I actually found some Judge Webster out of Fulton County, Georgia. She don't play. Yeah, our channel is growing a little bit. We had 85. Somebody dropped last night, but that's okay. They'll come back. We'll gain them back again. Yeah, I like all these judges. I love all these judges, especially Middleton. Actually, we were at 75 subscribers. We got 9 subscribers since last week. 8 or 9. That's pretty good, though. Let's get started before I run off at the mouth and forget what the hell I'm going to be doing. As well, I have a senior moment every once in a while. So let me make this a little bit bigger, but I don't know, it doesn't matter.
The government is banning this $97 smart cane next month, and this is your last shot to get the original military.
I don't need to hear anybody saying anything until it's their turn to talk. So just keep it quiet. This is Mr. Brown's turn to chat, and then I'll give you an opportunity. Mr. Brown, go ahead.
Your Honor, I do remember this. I am reviewing my notes on this particular matter. There was a hearing scheduled back on June 11th at, I believe, 10:30. Mr. Gallup did advise me. I received a text at 10:55. I did not read it until later because I was still in court, that he was having technical difficulties and that he could not log on. I believe that he may have eventually logged on. However, I brought the matter up again before the judge that afternoon to see if we could hear the matter. He denied that request and let the bench warrant stand. So this was a technical difficulty. He actually did end up appearing, but the judge in the circuit court would not rescind the bench order. So I believe that he would show up.
All right. Mr. Gallup, you also have the right to address me as to bond. I simply would caution you not to make any statements as to the facts of the underlying case because we are recording this and it may be used against you. But if there's any information that you wish to talk to me about the bond itself, I'd be happy to listen. I'm sorry, go ahead, sir.
I'm sorry, sir, that I didn't do anything wrong. I did show up. It was a server error is what it came up as. It says server error. And I sat there for 2 hours on the hearing, and now I get to double my bond, and I don't have any money. So I don't get to pay my child support on 3 kids. I don't get to pay my court fines. I don't get to pay my rent. I don't get to pay my phone bill. So now I'm going to be just here with you in court, in jail. And I would like to file a misrepresentation charge on Larry Brown Jr. because he didn't
Mr. Gallup, that's got nothing to do with bond.
I don't want him as a lawyer. I don't believe it.
Please. Mr. Gallup, nobody can hear you right now, so you're going to have to calm yourself down so we can talk to each other. If you will calm yourself down, I'd be happy to hear from you, but it has to be about bond, not everything in the world that you're mad about. You understand me?
Guy seems a little
Mr.
bit
Gallup,
pissed,
if you're not going to be calm, I'm not going to let you talk.
This guy is pissed off.
Are you going to be calm so I can chat with you or not? All right, turn him back on so we can chat with him, please.
The jail might have to accept it. Had asked on mute.
Yeah, Deputy, I believe that you're going to have to accept our request so we can turn him back on.
Here you go, Your Honor.
All right, Mr. Gallup, as long as you remain calm, I'll let you talk. But if you're going to get angry with me, I'm simply going to turn you off. You understand? Now, is there something that you want to tell me about your bond in addition to what you said already? All right. Mr. Gallup's bond was $2,000. Previously, it appears through his attorney that he did try to appear. So I'm simply going to reinstate his bond at $2,000, cash or surety, 10%. You're going to owe $200 to get out of jail. Mr. Gallup, that was your original bond. Next time you appear before the court, it would behoove you to act appropriately because you got pretty close to the line where I'm going to say, just because you're out of control, I was going to raise your bond. But if you will keep your head things will go all right for you. Do you understand, sir? All right.
Yeah.
Your bond is reinstated at $2,000 cash surety or 10%. That's all for today. Thank you.
Hello.
Good afternoon.
Good afternoon. How are you?
I am good. You want to just hold out on for a minute? We'll get the cases started in just a minute as I finish up my paperwork from what we were just doing.
Thank you.
All right, we have two matters. First is State of Michigan versus Samantha Lewis Millard, file 25-43682-ST. And then we have another case with Ms. Millard. That's file State of Michigan versus Samantha Lewis Millard, file 24-43338-SM. I do see Ms. Lewis Millard is with us. Ma'am, do you have an attorney?
No, I don't.
Do you wish to have an attorney? I'm sorry, I did not hear anything that you said, ma'am. Do you wish to have an attorney?
No, and I think we can settle out of court. Or without attorney.
All right, ma'am, I'm catching about every other word that you're saying, so you're gonna have to get closer to your phone and speak a little more slowly.
I think we go without an attorney.
I'm still only catching about half of what you're saying.
I think we can schedule it without an attorney.
All right, thank
No
you.
attorney.
I heard you that time. All right, if in the future you wish to change your mind, you can certainly do that, but we'll proceed today without an attorney. We are set for a status conference, which means a decision about what you want to do with the case. Mr. Fortier, has there been an offer made in these matters?
There has. It's plead to one, dismiss the other.
Does it matter to you which one is which?
No.
All right, I believe these are both driver license suspended.
Right.
Mr. Fortier, one of these tickets has a second offense notice on it. Is it your
That was
understanding?
dismissed.
All right, so we'll dismiss that. So the offer is plead to one count of driving license suspended, dismiss the second offense notice, and dismiss the other file completely. Is that accurate?
Correct.
All right. Ms. Lewis Millard, would you like to do that, or do you need some additional
Yes.
time to consider that?
Nope. I'll do it.
All right.
You think you're fine after a car accident until this happens. Most people don't realize that even accidents.
Judge, it looks like it'd be easier if she pleads to the 24-43338 case, and then the 43682 case would be dismissed.
All right. I do not see a clean action sheet. Print me one. I'm missing some paperwork, so if you just hang on for a minute while we get that taken care of, then I can proceed on these cases. Actually, print me two, do this, please. All right. Ms. Lewis Millard, while we're waiting for that paperwork, there's some rights that I need to advise you of so that you understand them before you can say that you want to waive them. In both of these cases, because they are criminal offenses, you have the right to have a trial by a judge or by a jury. At trial, you'd have the right to see, hear, and question the witnesses. If you wanted to have an attorney represent you, an attorney could represent you at that trial. You'd also have the right to present your own witnesses in your own defense and get an order from the court called a subpoena to require witnesses to appear and testify on your behalf. You'd also have the right at a trial to testify yourself, or you could remain silent, and that silence could not be used against you. You'd also have the right to be presumed innocent until proven guilty beyond a reasonable doubt, and to have that burden of proof remain with the prosecutor at all times. Finally, at a trial, you'd have the right to appeal automatically. However, if you enter a plea in the future, you'd only have the right to ask the court for permission to appeal, and that might be denied. You understand all of those rights that I've just explained to you?
Yes, sir.
Do you have any questions about any of those rights?
No, sir.
All right. Knowing all of those rights, is it still your desire to enter a plea today pursuant to this agreement with the prosecutor?
Yes, sir.
All right. Let me catch up with my paperwork here for just a minute.
Mm-hmm.
All right. In order to take a plea from you, I have to get some testimony from you. So would you raise your right hand, please? You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Correct. Yes.
All right. Has anybody promised you anything other than this plea agreement in order to get you to plead today?
No.
You can put your hand down, ma'am. You don't have to keep it up. Has anybody threatened you in any way in order to get you to plead today?
No.
Are you doing this of your own free choice and free will?
Yes.
All right. The charge against you in file 24-43338 says that on or about December the 15th of 2024 in Bagley Township of Otsego County that you did drive with your license suspended on Kasuba Road near East M32. Is that true?
Correct.
Do you remember what vehicle you were driving at that time?
2020 Dodge Charger.
And do you know why your license was suspended at that time?
It's fines. I pay my fines.
All right. Mr. Fortier, any additional questions as to a factual basis?
No, Your Honor.
All right. Are you aware of any other promises, threats, or inducements not stated on the record?
I am not, Your Honor.
You believe I've complied with the court rule?
You have, Your Honor.
All right. Ms. Lewis Millard, are you asking me to find you guilty of this offense because you are in fact guilty?
Yes.
All right. I will accept your plea. I do find that it was knowingly, intelligently, and voluntarily made. You have given me a proper factual basis and that you've admitted on December the 15th of last year that you drove with your license suspended on a public highway within Otsego County, being Kasuba Road in Bagley Township. So I will accept your plea. And I'll ask the prosecutor to file a dismissal form called a nollie in the other file as per the agreement. Ms. Lewis Millard, do you wish to proceed directly to sentencing today?
Yeah, we can.
All right. Mr. Fortier, any issues with that?
No, Your Honor.
All right. Ms. Lewis Millard, I'm going to ask the prosecutor for his comments as to what he thinks an appropriate sentence would be, and then I'm going to give you that same opportunity. Mr. Fortier, what do you think? What would you ask me to do?
Judge, I would ask that the court just issue fines or order fines and costs.
All right. Ms. Lewis Millard, any additional statements that you want to make as to sentencing?
No, thank you.
All right. I am going to accept the prosecutor's request. There's a $75 crime victim fee, $50 justice assessment, court costs of $100, local costs of $15, and a fine of $75.
Are you still stuffing your kangaroo hoodie pockets? You need the new 340 GSM mil.
A total of $315. How long do you think that you'll need to pay that off, ma'am?
You can set up a payment arrangement. Probably like 6-7 months because I have other cases that I'm paying on too.
All right. If you're going to do that, then I'm going to have to put you on probation and have you pay it over the course of your probation.
And how long will I need to pay it off? I have probation.
I'm not able to hear what you're saying when you talk that fast.
How long would I have to? How soon would I have to pay it off not to have probation?
30 days.
How much was it? 300.
315.
I can pay it off.
All right. I'll just say pay within 30 days. If you don't pay within 30 days, then we'll probably have another hearing and put you on probation at that point.
Okay.
All right. Do you have any other questions?
Nope, that's it.
All right. That'll be the order of the court then. Thank you.
Yeah.
I have to say this. In the words of Honorable Judge David Flesher, I don't give a rat's ass if Mother Teresa is late for church. Don't drive.
All right. The next matter is the state of Michigan versus Ricky Bear. That's file 25-43738-ST, set for a status conference.
Yes, James Dick on behalf of Mr. Bear. Mr. Bear is here on Zoom, Your Honor.
I do see Mr. Bear on Zoom. This is set for a status conference. Do we have a resolution of this matter?
Yes, we do, Your Honor. Mr. Bear will be entering a plea to allowing an unlicensed driver to operate his vehicle in exchange for a dismissal of the original charge.
Mr. Portier, is that an accurate statement of the agreement?
It is, Your Honor.
All right, Mr. Bear, you've heard what the attorneys have said. Is that what you want to do?
Yes, sir. Yes, Your Honor.
All right, it's my understanding that the offense that would be dismissed would be no operator's license or multiple licenses. That's generally referred to as no ops. That's a misdemeanor offense. And that you would be pleading to allowing an unlicensed person to operate a vehicle. That's also a misdemeanor offense, but typically it just has fines and costs attached to it. And in addition to that, it's not reported to the Secretary of State, so it doesn't go on your driving record. Understanding all of that, is that what you want to do today?
Yes, sir. Yes, Your Honor.
All right. There are certain rights that you have right now that you'd be giving up in order to take that agreement. So I want to make sure that you understand those. So let me tell you what they are. You would originally have the right to have a trial by a judge or by a jury. You could have Mr. Dick continue to represent you at that trial. You could see, hear, and question all the witnesses at trial. You'd have the right to present your own witnesses and evidence and get an order from the court requiring those witnesses to appear and testify. You could also testify, or you could remain silent. And if you chose to remain silent, that silence could not be used against you. In addition, at the trial, you'd be presumed innocent until proven guilty beyond a reasonable doubt. And that burden of proof would remain with the prosecutor at all times. Finally, at a trial, you'd have the right to automatically appeal any error at that trial. However, if you enter a plea, you're limited to asking the court for permission to appeal, and that might not be granted. Do you understand all of those rights?
Yes, sir.
Do you have any questions as to any of those rights?
No, sir.
Knowing all of that, do you still intend to enter a guilty plea today?
Yes, sir.
All right. I need to take some testimony from you, so would you raise your right hand so I can swear you in? You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right. Thank you. You can put your hand down now. Has anybody promised you anything other than this plea agreement to get you to plead guilty today?
No, sir.
Has anybody threatened you in any way to get you to plead today?
No, sir.
Are you doing this of your own free choice and free will?
Yes, sir.
All right. The amended charge of allowing an unauthorized person to operate a vehicle would read as follows. It would say that on or about May 13th of 2025, within the city of Gaylord and Otsego County, that you did allow an unauthorized person to operate a vehicle upon the Iron Bell Trail near the Lake State Railway. Is that true?
Correct.
Can you tell me what vehicle was being used at that date and time?
A 2020 Chevy Sonic.
And what was the reason that you or the person that was operating did not have a valid license?
My license was suspended out of North Carolina. I did not, was not made aware of it because I've been up here for a couple of years.
All right. So you found out that your license was suspended, and then the police wrote you a ticket for it, right?
Correct.
All right. Either attorney have any other additional factual basis questions?
No, Your Honor.
No, Your Honor. Thank you.
Either attorney aware of any other promises, threats, or inducements not stated on the record?
No.
None.
And have I complied with the court rule?
You have, Your Honor.
Yes, you have.
All right. I will accept the accept the plea, and do find that it was knowingly, intelligently, and voluntarily given to me based on the answers to the questions. And then I also find that Mr. Bear has given me a proper factual basis, and that he admitted on May 13th of 2025 to operating as an unlicensed, unauthorized person because of his license being suspended within Otsego County on a public highway, that being the Iron Bell Trail, or an area open to the public operation of vehicles. So I will accept that plea.
Honey time. 1 spoon before bed and 0 memory lapses. This is what happens when the honey trick works.
Is there any reason why we should not proceed directly to sentencing?
No.
No, we would request that the court does so.
All right, Mr. Bear, I'm going to ask each of the lawyers to tell me their thoughts as to sentencing, and then I'm going to give you the same opportunity to address me. So we'll start with the prosecutor, Mr. Portier.
Judge, I just ask that the court order fines and costs.
All right. Mr. Dick, your allocution?
Likewise, we would request that the court just issue fines and costs, and Mr. Bear does currently have a license again. As you mentioned, he wasn't aware of the suspension until he was stopped. Once he became aware of that, he did clear it up and was able to obtain his license again.
All right. Mr. Bear, is there anything else that you want me to be aware of that hasn't been stated already?
No, sir.
All right. The court will, as it typically does in these cases, apply fines and costs only of $290. Can you pay that within the next 30 days, sir?
I should be able to pay at least part of it within the next 30 days. I might need to ask for an extension to 60.
All right. I'm going to say pay it within 30 days and try to do that. If you have to ask for an extension, sometimes I have to put you on probation, and there's an extra cost for that, and I don't really want to do that up front. So let's see what you can get done. I don't want to tell you to beg, borrow, and steal it from somebody else, but that might be a great idea to get it taken care of here and then pay somebody else back later if you need an additional amount of time. Any questions that you have, sir?
No, sir.
Mr. Dick or Mr. Fortier, any other questions?
Actually, I'm sorry. I have one question. Where do I go to pay that? Do I just go to the courthouse, or?
I'm going to give you a phone number that you can call and take care of that. All right.
Okay.
That's. Do you have something to write with?
Give me just a second. I do now.
989-731-0201.
989-731-0201.
That's it.
All right.
Thank you. That's all for today, sir.
Thank you. Yeah, have a nice day.
Yeah.
All right. The next matter we have is State of Michigan versus Nathan Curley, file 25-43827-SM, set for a status conference.
James Dick on behalf of Mr. Curley. Mr. Curley, please turn on your camera. There we go.
All right. I do see Mr. Curley now. This is set for a status conference. Mr. Dick, do we have a resolution of this matter?
Yes, we do, Your Honor. Mr. Curley will be pleading guilty to the retail fraud second. And yes, the prosecutor was not advocating for jail time in this matter.
Is that an accurate statement of the agreement, Mr. Fortier?
It is, Your Honor. There's also a restitution amount of $371.20 to Walmart.
Correct.
All right, Mr. Curley, you've heard what the attorneys have said. Is that what you want to do?
Yes, Your Honor.
All right. The original charge was retail fraud in the second degree, so the prosecutor is asking that you plead as charged to that. That is a misdemeanor offense. It has a maximum penalty of 1 year and/or I believe a $2,000 fine. In exchange for that, the prosecutor is not going to recommend any jail in this particular case. Is that your understanding of the deal?
Yes, Your Honor, it is.
All right. In order to take that deal, you'd have to give up what are known as your trial rights. So let me tell you what those rights are so that you can make an informed decision. You have the right to have a trial by a judge or by a jury. You'd have the right to have your attorney, Mr. Dick, continue to represent you at that trial. At trial, you'd be able to see, hear, and question all the witnesses. You'd be able to present witnesses and evidence on your own and get an order from the court requiring your witnesses to appear and testify. You could also testify yourself, or you could remain silent, and that silence could not be used against you. You'd also have the right to be presumed innocent until proven guilty beyond a reasonable doubt, and to have that burden of proof remain with the prosecutor at all times. Finally, at a trial, you'd be able to appeal automatically any error at that trial. However, if you enter a plea, you'd be limited to asking the court for permission to appeal, and that might not be granted. Do you understand the rights that I've just given to you?
Yes, I do, Your Honor.
Do you have any questions about any of those rights?
I do not, Your Honor.
All right. Knowing all of that, do you still wish to enter a plea today?
Yes, I do, Your Honor.
All right. I need to take some testimony from you, so would you raise your right hand so I can swear you in? You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
All right. You can put your hand down, sir. Has anybody promised you anything other than this plea agreement to get you to plead today?
No, sir.
Has anybody threatened you in any way to get you to plead today?
No, sir.
Are you doing this of your own free choice and free will?
Yes, I am, Your Honor.
All right. The charge against you reads as follows. It says that on or about June 16th of 2025, within the city of Gaylord and Otsego County at the Walmart located at 950 Edelweiss Village Parkway, that you did commit the act of retail fraud in the second degree, in that you did, while the store was open to the public, steal property that was offered for sale there of a value over $200 but less than $1,000. Is that what you did?
Yes, Your Honor.
Can you tell me what it is that you stole from the Walmart store?
Yes, Your Honor. I'm ashamed to say it, but the items were basic household items, some disinfectant, cleaner, antibacterial, laundry detergent pods, and girls' sandals.
All right. You believe that those added up to more than $200?
No, there was other items that were included on behalf of Walmart from previous times on different dates that I am aware of. Obviously, just not.
All right. So all within a year's period of time.
I'd say with
All right.
a couple months.
All right. Thank you. Any additional factual basis questions from either of the attorneys?
No, Your Honor.
No, Your Honor.
Either attorney aware of any other promises, threats, or inducements not stated on the record?
No.
No, Your Honor.
Do both attorneys believe that I've complied with the plea taking court rule?
You have, Your Honor.
Yes.
All right. I will accept the plea entered by Mr. Curley. I do find it was knowingly, intelligently, and voluntarily given. He did admit the elements of retail fraud in the second degree, indicating he stole items offered for sale while Walmart was open to the public, and that was the Walmart that was here in Otsego County. That the value was over $200 in total from all of his thefts from Walmart. So I do believe that that was a proper.
Let this small device sit in your home to generate clean, free energy and never worry about power bill.
Plea, and we'll accept it. All right. Is there any reason not to proceed directly to sentencing?
No, Your Honor. I don't believe so.
There's not.
All right, Mr. Curley, what I'm going to do as for sentencing is I'm going to give each of the attorneys an opportunity to tell me what they think a proper sentence would be. And then I'm also going to give you an opportunity to address me at the end so that you can hear what they have to say first. Mr. Portier, go ahead.
Your Honor, naturally here, the most important thing that we're concerned about is the restitution to Walmart, which I've already given to the court. So outside of that, I would leave any sentence up to the court. Would state that I did indicate to Mr. Dick that I would not be advocating for upfront jails. I don't think that's necessary at this point. Just the main thing is just that the restitution gets paid.
All right, thank you. Mr. Dick, allocution?
Yes, Your Honor. Mr. Curley, he's a 36-year-old father of two. This incident occurred around the time of the ice storms and whatnot. Mr. Curley believed he was only doing what he needed to provide for his family, as can be recognized by the items that were taken, specifically cleaning items, clothing items, basic necessities. Mr. Curley, he does feel horrible for this. He's rather embarrassed. Since he was having those hard times, he's been able to get back into work. He does drive up north for work each day. He just finally really started picking up and being busier and making enough money to support him and his family since this summer. He really didn't have any other work this earlier this year with his two young children at home and his wife. He was the only one working. He is taking full accountability and responsibility for his actions here. And he does acknowledge the restitution and intends to pay that back. He doesn't have any recent significant criminal history. I believe most of what he had was when he was younger, more than 10 years ago. However, he may have an OWI from a number of years back as his most recent offense. He has, since that, he's been sober and really focused on his family and whatnot for about 6 years. With that, Your Honor, we just ask that the court takes into consideration this was not done as a malicious thing. It wasn't done for personal gain. It was done as a means of survival. And while we all recognize that there are other ways that this could have been handled, unfortunately, at that time, he did what he did, thinking that he didn't have another choice. We would just ask that the court assesses minimal fines and costs in this. And of course, we understand that there's likely a short period of probation as well.
Mr. Curley, you also have the right to address me as to anything that you think that I should be aware of about you. This is your opportunity, sir. Go ahead.
Yes, Your Honor. Mr. Dick pretty much stated everything. Essentially, that I'd want to say. I am really ashamed and, definitely embarrassed. Unfortunately, it's what it is, and I made those choices, and obviously there's consequences. I just wanted to apologize, I guess, essentially to Walmart or anybody that had to deal with it. The courts as well. All I can do is just move forward and obviously make better choices. But beyond that, like I said, Mr. Dick pretty much stated everything, and I just obviously want to move forward and, get back to life. I'm sorry, that's all I have to say, Your Honor.
Thank you,
My
sir.
apologies.
No, you're all right. I'm just looking at some materials here I'm going to ask you about in just a second.
Okay. Yeah.
Now, during this limited time, Never Go Dark Ultimate Upgrade event, you get a collection of free gifts.
Mr. Curley, I'm looking at your criminal history. This is the first time that I've seen it. So I want to make sure that it's accurate. You have a prior conviction for false pretenses between 200 and 1,000 out of the 65A District Court in May of 2010.
That is Clinton County.
Yes.
Yeah. It actually was my mother's debit card. I had taken it.
You don't need to tell me. Go ahead. Go ahead.
My apologies.
No, that's all right. Go ahead.
I had taken her debit card, or well, I'd already had it, but I didn't give it back, and made some purchases with it, and those were the circumstances of that. And she called and reported it.
All right. Do you also have a conviction out of the Shiawassee County Circuit Court in December of 2010 for home invasion 3rd degree felony offense?
That's correct, Your Honor.
You also have a home invasion 2nd degree in October of 2015 in the Saginaw Circuit Court?
That's correct, Your Honor.
You also have a misdemeanor attempted retail fraud 3rd degree out of the Shiawassee District Court in February of 2012?
I recall, Your Honor.
You also have a conviction for financial transaction device stealing or retaining in August of 2015 in the Otsego County Circuit Court?
Yes, Your Honor. That was old girlfriend.
That also included a retail fraud 3rd that went along with that financial transaction device?
Yes, Your Honor.
And then in January of 2020, in the 87th District Court for Otsego County, conviction for retail fraud 3rd degree?
I'm sorry, what you said?
January 30th of 2020 in this court, conviction for retail fraud in 3rd degree.
Oh, yep, I do, from Walmart.
All right. And then June 11th of 2020, another retail fraud 2nd degree in this same court?
I honestly, I don't recall that one, Your Honor. I know there was an incident. This is before I got sober, when I was still drinking. And most, if not all of these are attributed to choices I was making when I was drinking, of course, which doesn't excuse anything. But I had started drinking a bottle of wine inside the store, and I left with it. It was, I think, the circumstances of that. And I mean, I was intoxicated and vaguely remember most of it, but yeah, drinking was a huge problem for me.
What have you done since then? What have you done since then about that?
I've been sober 6 years from alcohol. I did have the driving impaired 2020, 22, 21, 21.
This says March, you were arrested in March of 23 and pled sentence in October of 23.
Yes, I had taken too much medication, pharmaceutical, for anxiety, and I had got in a confrontation with a tow truck driver during some bad weather. I was stuck in the ditch, and unfortunately that led to police obviously worried about my ability to drive, and I told them, Beyond that, I mean, I've definitely made some poor choices, Your Honor. The home invasions, all people I knew, family, old girlfriend, and just went about things the wrong way and made some bad choices. I lived kind of a rough lifestyle growing up, and I'm originally from downstate in the Flint, Owasso area, Shiawassee, Genesee County. I like I said, made some bad, poor choices when I was really young, and didn't really understand the severity of it until, it catches up with you and it follows you, and another bad choice will only make it worse. The last thing I want to be involved in is the courts and anything like that, and I thought those days were over, and I've really got to make the right choices. I've really got to I know right from wrong. I know what is and what isn't. Like I said, Your Honor, I just want to move forward and just hopefully move past this and get on to better things.
Mr. Dick, is there anything else that you want to say on your client's behalf?
This $40 compression tank top makes you look 30 pounds thinner instantly and shuts down all the dad bod comments for good.
Well, Your Honor, just again, I know he acknowledges the fact that he has the previous charges and whatnot, or convictions and whatnot. I just do want to reiterate that they are, for the most part, they're a little bit older. He's been keeping his nose clean aside from that OWI for the most part. That being said, no, I don't have anything else, Your Honor. Thank you.
All right, thank you. I'm not going to follow the prosecutor's recommendation in this case. Even euphemistically, Mr. Curley has not kept his nose clean. He's had 15 straight years of involvement with the court system. He has multiple misdemeanors for the exact same charge that he's done this time. Tells me that in the past it was alcohol or drugs that caused him to do it, but apparently now that he's clean, he's back doing the same thing before. This was not a mistake. This is a very clear pattern of behavior. Whenever, for whatever reason, he gets short on cash, he goes to his local Walmart and makes a withdrawal. And that's illegal behavior. And he's been in jail and out of jail and done felonies and done misdemeanors, been on probation and not been on probation. And there's a clear pattern of behavior. I can't just look the other way. I can't just say, well, today's a new day and it's okay. We'll just treat you as a first offender. He's not even a fourth or fifth offender. He's got 8 or 9 of these things. My counting might be a little bit off, but not much. And he hasn't gone more than 3 or 4 years without getting another conviction. Been in prison. He's been in jail. He's been on probation. I'm sorry, but when we started talking, this sounded to me like it was a first offense, maybe a mild second offense, and that was the reason for the plea offer. But that's not the case. So he's going to be on probation for 720 days. That's the most I can give him because I need to have a handle on him. There's going to be a $75 crime victim fee, $371.20 in restitution, $50 justice assessment. There's a $400 court cost, $200 fine, $15 local fee. Let me add that up for you as a fines and costs. The total of, with the restitution amount, is total of $1,111.20. Pay that over probation. He may work some of that off by a community service, but some of that's going to have to be paid in in person because he can't work all of it off. I'm going to require him to enroll in an economics crime course. That's a series of videos that he'll have to talk with probation about. While he's on probation, he's not to consume or possess alcohol or drugs. No entrance into a business where alcohol is served by the glass. That means no bars. You can go into a restaurant that happens to serve alcohol, but you may not go into a bar that happens to serve food. Drug testing is ordered by the probation or the drug line. May not enter Walmart. And you must do 60 days in jail, 60 days forthwith. Here at the Otsego County Jail today at 6 p.m.
Yeah, I'm gonna lose everything.
That's your own fault, sir.
Your Honor, I need this job.
What you
I
need to
know
do
I'm-
is stop stealing from your community.
I know, Your Honor. I take full accountability, but if I go to jail, I'm seriously going to lose
This is
everything.
part of that full accountability, sir. 60 days in jail is not the most that I could give you. You're lucky I
No,
only
I know.
did that.
My wife just had surgery, Your Honor.
You don't appear at the jail today at 6 p.m. We'll send officers looking for you after we issue a bench warrant. That's all for
Your
today,
Honor.
sir.
Oh, man.
Give him, please. Next case is State of Michigan versus Jonathan Bowers. File 25-43858-SM. Set for sentencing.
You're going to speak on behalf of Mr. Bowers. Mr. Bowers is appearing by Zoom, Your Honor.
Hey, John.
All right, I do see Mr. Bowers is with us. This was a domestic violence plea with a 769.4A delay of sentence status. And we adjourned it to today's date, I assume, for the victim's information. Mr. Portier, do we have any additional victims information?
It appears that the victim wanted to speak. I think Ms. Weber from my office might have a little more input, though.
I believe Emma Murphy is the victim, and I do see her in
Yes.
the courtroom.
All right, Ms. Murphy, are you present with us?
Yes, Your Honor, I'm here.
All right, thank you. You have the right to speak at sentencing and to tell me what it is that you want me to know about this case, so I'm happy to listen to you now if you'd like to go ahead.
Yes, Your Honor. Honestly, I never really wanted any of this to happen. I didn't make the phone call to the police in the first place. It was just a misunderstanding that got out of hand, and I miss him a lot, honestly. His son misses him. I mean, the dogs even are not acting the same without him around. Life is hard, harder than it used to be, and I've been, trying to just think of ways to explain how, I wish none of this happened. I feel really bad, and I want to work things out, and I wish that, like I said, none of this even happened in the first place. But, yeah, I mean, that's really about it, Your Honor.
How long have the two of you been together?
We've been together about 5 years.
Okay. Do you believe that the two of you need any sort of counseling to make sure that this doesn't continue to be an issue?
I mean, I wouldn't be upset if he got some kind of therapy, but I don't think it needs to be like court ordered.
How do I make sure that this doesn't happen again?
I would like to just say that, it was mostly just due to his drinking. And when he doesn't drink, he's a wonderful partner. He's a great dad. He's a good friend. He goes to work. He does what he's supposed to. You know, I guess as long as he stays away from the alcohol, everything should be fine.
Why do you think that he does that when he drinks? What is it about him and alcohol that causes that?
I feel like he might have some trauma, some things that happened to him in the past where he gets angry when he drinks, and I feel really bad for him, honestly. I wish that he was, you know, healthy and could enjoy life and be happy without alcohol.
All right. My experience in the past, I work with the recovery court here in Otsego County, and I've been a lawyer for a long time with prosecution and defense. So my experience with alcohol in the past has been that it takes away your inhibitions. It takes away that part of you that stops what is already inside of you. If you got a bad thought in your head and you don't drink alcohol, you can stop it, but the alcohol takes away that gatekeeping function, and that whatever is inside tends to come out, which leads me to believe that most people who act as angry when they've been drinking have anger inside of them already. It sounds to me like you think that that's true as well, and he might need some assistance with that. Would that be accurate?
Yeah, I don't think it would hurt.
All right. Is there anything else that you want me to know, Ms. Murphy?
No, not really, Your Honor. I just hope that, you know, you could see that this wasn't something that, you know, was supposed to happen in the first place. Even really, it was, like I said, just a misunderstanding that got out of hand.
And you're asking that he be allowed to have contact with you immediately, is that correct?
I would appreciate that. I'm sorry.
That's all right. I understand.
Like you said, I miss him. His son misses him. I feel like I'm not even, you know, I'm not happy without him here. Even though we did have that one incident, life is very hard without him.
And I can certainly understand that. I just don't want life to be hard with him as well. And that's my concern, that if it happened once, it may happen again. And then we've got an even bigger problem, both for you and for the court system.
Yeah, I understand completely. And that's what I was thinking. Maybe, you know, some type of therapy or counseling or something maybe along those lines wouldn't be a terrible idea.
Okay. All right. Anything else that you want me to be aware of?
No, Your Honor, that's it. Thank you for listening.
All right. I appreciate you being here, and I know this is difficult for you to do, so thank you very much for your time. All right, Mr. Bowers, I'm going to give the attorneys also an opportunity to address me now. I'm going to start with the prosecutor and then your attorney, and then I'll turn to you so you have the ability to hear everybody and can respond after that. All right, sir? Mr. Fortier, your thoughts?
Yes, Judge qualifies for deferral, and I believe that's the offer that was made. So I would just ask the judge to, I would just ask the court to follow that.
All right. Mr. Dick, your allocution?
Yes, Your Honor. So Mr. Bowers, he's a 30-year-old father. Him and Miss Murphy have one child together. He has been attending AA. He's only gotten a couple sessions in thus far. However, it's my understanding that he does intend to continue with this. He was trying to find a location to attend previously when he was up north farther. He was just having some trouble finding the actual locations because he wanted to be somewhere physical so he could physically interact with others.
The government is banning this $97 smart cane next month, and this is your last shot to get the original military.
Mr. Bowers, he's been kind of finding himself a little bit since this incident as well. he does take ownership for drinking and how he acted. He did, however, find himself for a short period in sober living up in Petoskey. He did also end up, I believe, camping for a little bit, working on himself, all while continuing to work because he was still sending money home to take care of his, Miss Murphy and their child. This particular incident, it was surrounded by an argument and a couple people pushing on the door and yelling, and ultimately Mr. Bowers here did admit that he did push Miss Murphy. He is currently working. He's back here in Gaylord. He's working full-time, and he is currently residing with his mother, who lives also in Gaylord. He is able, he did want to make sure it was known that he can pay for any testing that the court would require, and he's willing to do any sort of counseling, anything else that the court would deem necessary to allow him to ultimately return home to his family, which is Miss Murphy and their child. With that, Your Honor, we would just ask that the court affords 769.4A and a reasonable term of probation, and also fines and costs in some sort of a reasonable manner. But
all right,
that's all.
Thank you, Mr. Dick. Mr. Bowers, is there anything that you want to tell me specifically?
Getting back to my son is the biggest thing. Being able to be a family with Ems and Dimitri is everything to me. Making sure they're safe and both tucked in at night. I would just really appreciate to make sure I have that opportunity. And, I understand your concerns and your fears. And I can assure you that I'm not going to be fighting with her. I'm not going to be drinking. I know that what I've done was wrong. I know that I have placed my family, in a bit of a situation with my own actions, and things have been made stressful upon my child. And I'm the one to blame for that. He needs his father, and his father made actions and decisions and choices that led to him not being there. And if there is one person that's been hurt by this the most, it's definitely my son, and that is 100% on me, sir.
Well, I appreciate those thoughts, and I'm glad to hear them from you, because it tells me that you've been spending some time thinking about what happened and what caused this and how you can fix it. So I'm pleased to hear that you are at least in the thinking stage of doing things about it. It also sounds to me like you have been doing some actual actions as well. Your attorney mentioned sober living, AA, those sorts of things. And the fact that you've been supporting your family while you've been away from the home also tells me that you're trying to do the right thing. So for that reason, I am going to give you the opportunity to show me that you can do the right thing. And I'm going to go relatively easy on you. I'm not going to hold your feet to the fire as much as I could under other circumstances. So I am going to give you 769.4A. What that means is that if you successfully complete this probationary term, you won't have a criminal record as to this, and the case will be dismissed against you. However, if you don't successfully complete this, then you will have that on your record. And if there's any violations of the court's probation, you could be brought back in and sentenced to an additional penalty for that. So that's how that process works. But I think you've earned the initial carrot, if you will, of having this available to you so that you can keep it off your record and it doesn't hurt you in the future. In addition, I found the statement from Ms. From the victim in this case to be heartfelt, from Ms. Murphy to be heartfelt and to be well thought out. She indicates that she misses you, but she also recognizes that you've got some work to do. So she's not just minimizing things. I think she's looking at things straightforwardly. And you would do well to listen to her counsel in the future if there's any issues that come up. And I would encourage her to speak to you directly and say, hey, don't start down this path again, because this is what led you to the problems in the past. All right?
Hey, if you think a fanny pack is going to help you when you head outdoors, think again.
So I am going to give you an opportunity to be with your family immediately. I'm not going to keep you away from them now, but that comes with you doing what you're supposed to be doing. And so I'm going to give you some things to do while that's occurring. All right? So here's the sentence of the court. I'm going to put you on probation for 1 year, simply because I want to make sure that you stay on the straight and narrow. After 6 months, you will be allowed to ask the court for permission to get off of probation. But that assumes that you've got everything done that you need to get done. All right? The probation will cost you $360. There's a $75 crime victim fee, a $50 justice assessment. I'm going to reduce the court costs to $100, local charge of $15, and a fine of $50. $290 plus $360 of the probation oversight fee. That's $650. You can pay that off over the course of your probation. You may perform community service in lieu of some of those fines and costs at the discretion of the probation officer. You must enroll in and successfully complete a treatment program. I'm going to ask that you get screened for substance abuse and follow their recommendations. And your attorney, Mr. Dick, can assist you with where to go to get that assessment done. That'll cost you a few dollars to do that. But instead of trying to figure out what you need on your own, I want to have a professional tell you, all right, here's what you need to do, whether that's a alcohol highway safety class, or whether that's a victim impact panel, whether that's inpatient, whether that's AA, I don't know. But I want an expert to tell me that, and then you follow that recommendation.
Okay.
I'm also going to ask you to be screened for anger management by a person with some counselor credentials, and follow the recommendations. Again, there may not be any anger issues that you have to deal with. There may be whatever the counselor recommends is what you're going to need to do, and follow that recommendation so that you don't have this problem in the future. And those are the two big things that I want you to do while you're having contact with your family. So that's kind of what I'm saying. If you're going to have contact with your family, you've got to do these things and follow these recommendations. And if you don't, I'm just going to pull your ability to see your family.
I understand.
All right. Because you've had problems with alcohol in the past, I'm going to say no consumption or possession of alcohol or drugs. No entrance into a business where alcohol is served by the glass. That means you can go into a restaurant that happens to serve alcohol. You may not consume it. You may not sit in the bar, but you may not go into a bar just because it happens to serve food. You understand the difference between those two?
Yes.
All right. I'm not going to put you in jail because you're on 769.4A. I'm not going to give you work camp because you're on 769.4A. But those two things are on the table if you mess up. You understand? All right. Do you have any questions for me as to what's required of you?
I do not believe so, no, sir.
All right. Mr. Dick, any questions?
No, Your Honor. Thank you very much.
All right. That'll be the order of the court, sir. You'll need to contact the probation department. You can reach them at the following number: 989-731-0215, and they'll assist you if you don't know where to go for substance abuse and anger management. Mr. Dick may also be able to assist you with that, and then they'll also assist you with getting started on your probation and paying off your fines and costs. All right, sir?
Thank you very much. I appreciate
All
you.
right. I'm going to just make a note that the bond condition of no contact is lifted. You may have
The no drug.
Yep. What about it?
Does that include marijuana by chance?
It does.
Okay.
I don't want you substituting one controlled substance for another. If you're going to have a problem with alcohol, I don't want you numbing yourself with marijuana. I want you to deal with whatever the underlying problems are. All right. If you've got issues that you can't accept reality, I want you to deal with it so that you can accept reality. Your son needs you present, and needs you at full working capacity. You understand that?
Yeah.
All right. So you may have immediate contact with the victim. That's Ms. Murphy, Emma Murphy. All right.
Yes. Yes.
You've been given a gift here. Don't mess it up.
Oh, I won't, sir. I won't. I appreciate
right.
you, sir.
That's all for today then. Thank you. Good luck to you.
David Keeler Maldonado.
Yes, sir. We're ready.
Okay.
Normally, we charge $1,600 for one of them. Today, you get one free, which means.
What are we doing on him?
It's
Sentencing? Keeler Maldonado, is that you, sir? Come on.
What?
I really want to have it 12, but we said it kind of
Beautiful.
I think we pled it. In fact, I'm almost positive we did. Right now.
He's already pleaded guilty.
Yeah, I think it was reset because there was some risk and it was reset, but it was only like a few days.
Any flex, we could do that without. Is there another case that he's supposed to plead it?
Mr. Boyd, are you on this one?
Yes, Your Honor.
I believe Mr. Laird took the plea. No, Mr. Ham, I'm sorry.
What's your final answer, David? What's your final answer?
How many choices did I have? And I believe it was Mr. Ham.
We now call 24 CR 2392, the state of Texas versus Keeler Ivan Maldonado. So that is you, sir. Sir. Present with your attorney, Mr. Grove, and the state's attorney. Earlier, you pleaded guilty to the first-degree felony of aggravated robbery. A pre-sentence report has been prepared. Have the parties had an opportunity to review it? Are there any corrections or changes to it?
Nothing,
State.
Your Honor.
Well, what about
Your Honor, I reviewed the report with Mr. Maldonado and the defense says no changes to make to the report.
Then the pre-sentence report is made a part of the record for all purposes. The agreement is whatever sentence shall not exceed a cap of 12 years in prison. So we are looking at no less than 5, no more than 12 years imprisonment. Regular probation is not an option because a deadly weapon firearm was used in the commission of the offense, which gives the only other option to be deferred or unadjudicated probation, which can be up to 10 years in a length. I think those are the two options, correct, everybody?
That's correct.
That's correct, Your Honor.
All right. Go ahead, Mr. Grove, on behalf of the defense.
I'm going to be very brief, Judge. I believe that this is a very unfortunate thing that Mr. Maldonado was involved in.
Certainly was unfortunate for the victim.
Well, and it's unfortunate for Mr. Maldonado and the other folks that were there because there were a number of other people that were at least present. But I think based on Mr. Maldonado's past, and when I say his past, that's the lack of a past where he has had no prior felony convictions. He has been
very good as far as things goes until this deal here. And this was not in any way justifiable, but I believe Mr. Maldonado realizes that this could have been the biggest mistake of his life and that he isn't going to let it happen again. He also dropped out of school before he got his high school diploma. And I believe he realizes how important that is. At the time when this occurred, he was employed for the city of Port Arthur. So he was working at the time, but this is just very regrettable. And I believe that he realizes that. And if the court were to grant him deferred adjudication, I believe that would be in the best interest of everyone involved. And I ask for the court to do that, grant him a deferred adjudication.
State, what do you want to say?
Your Honor, obviously it's a very serious offense. However, it does appear from the facts and reading it that the defendant is not the one who actually pointed the weapon at the victim in this case. Obviously, we know that doesn't absolve him from that, but it does appear he doesn't have any other history. I don't think we would necessarily, in this case, be opposed to a deferred, but obviously, to the court's discretion. This did involve robbing a young man at a park that had pulled a gun out on him. And I believe after he told him, no, I'm not, going to give you my chain or whatever, they ended up leaving at that point after initially threatening him. And they were found shortly later in a parking lot. And there was a gun in that vehicle.
You think you're fine after a car accident until this happens. Most people don't realize that even
I believe that's true. There was no restitution, Judge, although if there was, then certainly we would be willing to pay that, but I don't believe there was any loss suffered.
Y'all read the pre-sentence report and the probable cause affidavit? It's completely different from what you're telling me. He was the one that came out with the rifle. He's the one that pointed the gun at the chest of the person. The others were all juveniles. He was the only adult in the group. That's what's clear in the pre-sentence report. And that's what's clear in the probable cause affidavit. Maldonado approached Contreras, demanded him to give him 2 necklaces that were worn by Contreras. During the time, Maldonado pressed the muzzle of the rifle up to the victim's chest, but he still refused to give him his property. After that, several other subjects in the gang of thieves exited his vehicle and came up to the lone victim who was helpless and demanded and threatened him to give up the necklaces. He still refused. Then the defendant and the others left. He was the only adult in the group. The other 4 juveniles are being processed as juveniles. Now, his version. I was with some other people. We stopped at a park. We saw this guy. We robbed him. They passed me the gun. I just went along with this, even though I didn't want to. So much for taking full responsibility. That doesn't help him. He can't even tell me the truth. He can't even tell the truth. At this stage, when he's got everything to lose by not telling the truth. All right.
Yes, sir. I would point out that he did.
12 years in prison. If I sentence you to 12 years in prison, you can't get out until 50% of it is served, at least. You'd have to be there for at least 6 years. Do you understand that? You want to tell me the truth about what happened now, or are you going to continue to lie?
Sir, like I said.
I'm sorry.
So I'm not lying, sir. Like I said, we went to the park.
Who stuck the gun in his chest, sir?
Who, me, sir? I had
All right. It's not what everybody's saying here. You were the oldest in the group, weren't you?
Yes, sir, I was.
Well, you know, had you fired the gun into his chest and killed him, there'd only be two choices. The death penalty or life without parole. Those would have been the only options under license. Really? You thought this was a wise idea? Why'd you pick on that guy?
Wasn't, sir.
Sir? Why'd you pick on? Was he just the most helpless person you could find?
Sir.
The most vulnerable person?
Yes, sir.
What?
I don't know. It's just wasn't. Okay.
Anything else?
No.
I'm still a little unclear about the state. What's the state asking for?
Your Honor, them not having the history, obviously it's very serious, would defer to the court, although I don't know that we would be opposed to the deferred in this, where he'd be facing the, obviously, the maximum range of punishment if he decides to screw up at any point in this.
Anything else? Anybody just a second?
Yes, certainly with the regular probation being eliminated by the state, by the law, not by the prosecutor. If Mr. Maldonado does screw up, the court has a much wider range of things he do. I think this will be the last time the court will see Mr. Maldonado. I think his background, although he has not been perfect, and in this case, there's no doubt that this is not justified.
Let this small device sit in your home to generate clean, free energy and never worry about power.
I believe that for whatever reason, he decided to do this before he had any other criminal history. And he wants to make a success of his life, and will be able to do so. And if he doesn't, then he's looking at 20 years in prison that the court could sentence him to.
How's that?
It'd be 5 to 99 or life.
How's that?
Oh, I'm sorry. I'm sorry. Five or 99. The court could be looking at giving him 99. I apologize. I was thinking it was second degree, but it's not. It's a first degree. He could get up to life in prison if the court decides to go ahead and revoke his probation.
Do you have any family here?
My parents.
Your parents?
Yes, sir.
And they've been all here in their prison. And I apologize.
Where did the guns come from? Where did the rifle come from?
It wasn't mine, sir.
I'm going to ask you one more time. That wasn't the answer to the question. Because the answers you've already given haven't been truthful up to now to the probation office or to us.
Came from a friend, sir.
Who?
The woman.
But what's the friend's name? They got a name? It's a friend. You know the name. I know all my friends' names. What's the friend's name? Don't look at him. Look at me. When you do that, that means you're trying to lie.
Daniel.
Huh?
Daniel, I think.
What's his last name?
I'm not sure.
No. How long have you known your friend?
I met him for like 2 months, maybe.
Where'd you meet him?
Off of another friend.
2 months ago?
Like 2 months I had met him.
I don't understand what you're trying to say.
No,
2
like,
months ago?
No, not 2 months ago. Like I had knew him for like 2 months.
Oh, when this had happened?
Yeah, like
when this event happened?
Yes, sir.
Where did you meet him?
Where did I meet him?
I asked you first.
Off of another friend. Like I met that friend off of another friend. It makes sense.
So how did this firearm thing come up? How did that?
We was all together at first. Like we was just together, and then we had went to the park.
Well, why were you selected to stick the rifle in the child's chest?
Sure, sir.
I wasn't there. You were there. You know what happened.
Sure.
Think about it while you make up a story.
Get him, George.
Okay. Anything else?
No.
All right. The agreement is a cap of 12 years. That's the most you can receive. 12 years in prison, no less than 5, nor more than 12 years confinement in prison. Do you understand?
Yes, sir.
All right. The court has reviewed this fully and has read the pre-sentence report and have you ever used drugs before?
Before, yes, sir.
Mm-hmm. When?
How old were you? Like around my 16 to 17.
You were 17 when this happened, right?
Yes.
You were almost 18.
Yes, sir.
Is that right? Or
yes, sir.
no, you had turned 18 by 1 month. Your date of birth is October 6th, yes, right? Of 06?
Yes, sir.
Okay, this happened November 2nd, 24. So you would have just turned 18, right?
Yes, sir.
Anything else?
Nothing, state, Your Honor.
Here's what I'm going to do. The cap is 12 years. Is a state jail felony of publishing or threatening to publish intimate matter, and the other is a state jail felony of theft. Now, let me ask, Mr. Cover has served almost 2 years in jail. 22, between 22 and 23 months. Is that the most he can get is a state jail felony?
Your Honor, what this priors is actually can be up to, he can be in.
Okay, help me out. I don't see the priors aren't. They're not this indictment.
They're not in this indictment, but he does have prior felony convictions.
Is he going to get notice? Is he going to get notice of that?
It's in the file.
Thank you, ma'am. What kind of, it's not in the indictment. Where is it in the file? Where have you received notice from them that they intend to present?
I got one that was from last year, but then it's been amended since, and I haven't seen it. At least that's what's on the computer.
I believe it filed before. I'm sorry. I believe that was when Mr. Kimmler was representing him. I believe it. But Your Honor, I believe I did file. I'll look, pull it up real quick. When Mr. Kimmler was representing him, I believe I filed the notice of intent to seek enhanced punishment.
Okay, is that the amended?
No.
One? That's what he needs the most updated.
Yes, sir.
Can you get a copy of course? Did you want? I don't know. So I can see what you're looking. I don't even know what it was. All I see is state jail felony.
Correct.
But if you have prior convictions and they give you notice,
that's for the punishment.
It could be the punishment
But until I found it, it's a state
It could
felony.
be up to second degree felony, depending upon what it states. All right, here's a first amended motion. All right. I notice. Here, give this to Mr. Butler. I handed this to you, Leo. All right, it states that you were finally convicted of burglary of a vehicle in 1980 in the 179th District Court of Harris County, Texas. I think that was a third degree felony back then.
Yes, correct, Your Honor.
It's not now, but if it is, then
I'm not even arguing any of the convictions.
I understand, but then next is that you were finally convicted of illegal possession of controlled substance in 1980. And before, in a different cause number, then it states you were finally convicted of aggravated robbery out of Montgomery County in 83. You were also convicted of another aggravated robbery in 1987 out of Sabine County. And in 1993, convicted of retaliation out of Sabine County District Court. So, each of those could, if one or more are true, or two or more are true, then those could enhance your punishment from a state jail felony punishment to a third degree felony punishment. But then you've got those last two paragraphs that state that after those convictions were final and before you committed this new offense, you were finally convicted
Well, it would just bring it to a second degree, Your Honor. Just their
what was the conviction?
If I'm mistaken.
What's the subsequent? Hold on, everybody. Let me talk. Let me talk. When I speak, everybody stops so she can take down, because she can't take down everything if we're all talking at once. What is the most recent conviction after those others we've talked about? Is it the aggravated robbery in 96?
Yes.
Okay. And then also escape in 96, right?
That's correct.
That's what this is showing. Okay. So those two are in sequence of the.
If you've got honey at home, you might be one step away from wiping out your memory problems. Many people.
Prior three, the five prior convictions, and if all of this was true, and you were convicted, then your punishment range then becomes second degree felony punishment range, up to 20 years in prison. Okay. But you've got a copy of that.
I don't think that's correct.
They got to prove it as alleged.
I mean, it says.
I know, but it's not.
It says aggravated.
Yeah, but it's, this isn't a debate here. It's what they put that in to give you notice. They better prove it, or else it's not adequate.
First, I have to be found guilty.
Yeah.
And I don't think that's going to happen.
Okay. You want to represent yourself.
Yes,
okay.
I do.
And you've thought about it long and hard, and this is have you ever represented yourself before in a trial?
Yes, sir.
Okay. Well, you know that the judge expects you to know the rules of evidence and holds you to it, and the code of criminal procedure and the penal code. Okay. And these guys went to law school, and that's what they do for a living. So you can represent yourself, but it's always been for the most part, it's been difficult for defendants to represent themselves against people like this. But you understand that and you wish to move forward. We can, how many witnesses do you intend to call?
Your Honor, there's only, I believe, four or five at most.
When do we want to when can we put this in for trial?
Judge, I have a special set on November the 4th.
Well,
3rd.
And Your Honor, we're trying to make sure Mr. Cover is allowed to go through all of his discovery on this, which I do have it tabbed out, and we're allowing him to see some of it, but there's a large volume of the electronic data on here that we're allowing him to go through. I think we're going to schedule it, I believe, for next week. We're going to schedule a day for him to come back and review it in the jury room back there again.
Pages and pages. It's going to take a minute.
Yeah, I know. It take as long as you need.
And my motions that I filed, I haven't had motion hearings.
Yeah, go over them. Which ones do you want to ask? What are you asking for relief for?
I'm asking because of the delay of trial, speedy trial. I've been trying to get a speedy trial. I haven't got it. I'd like to know about if the indictments. I don't even think I think I got a rubber stamp indictment. I don't think I haven't had a motion hearing. I haven't had discovery. I've been filing my motions. I haven't had any.
What motions are you asking for?
Nobody else is.
You did look at your motions. You asked me what motions. You're the ones that filed it. Get it before me. Come on. Yeah.
I want to hear the pro se motion for the writ habeas corpus. Writ habeas corpus.
What do you want to add? What do you want to add to that motion? What do you want to add other than what you put in the four corners?
Hear the motions heard, and I want to hear it in order.
No. What additional evidence do you want to add to it, sir?
Oh, I don't need any.
Then it's overruled. I've looked at it. Unless you have something different than what you put in the four corners, it's overruled.
Okay.
But it's preserved for error. But it's a preserved error.
What about the motion for the question set aside the indictment?
That is denied.
Okay. Am I going to get a written order on any of this, or are you just going to deny every one of them?
We're putting the order into the record. And if you want a copy, we can make that later.
I have a copy of all of it.
Are you going to interrupt me, Leo? Come on.
I haven't got a copy of his amended
sir.
briefs. I haven't got copies of nothing.
Sir, when the court speaks, you need to stop. You're going to get a fair opportunity to speak.
Yes, I don't think it's fair. You're denying everything I do.
We've done this once again.
How the hell
Leo,
is that fair?
when you shout over the court, she cannot do her job, and that's improper. She's got to take down everything. Leo, you may not like what's going on here, but please follow the rules. And if you have a right,
you're not. You just sit there and deny.
Sir, I have read this whole file, sir. You don't know. Are you clairvoyant?
Yes, I am.
All right, that is all.
Bullshit.
We'll see you at trial. Thank you, Leo. You can't be calling people names and speaking over people. It's rude, Leo. You know that. All right.
Did you know you can keep your critical devices in your home powered on during an outage? And without
and you get a speeding
No, we're not
ticket.
going to do that, sir. I just need.
All I want to know is the fine. Like normally when you get a ticket or a citation, somebody give you.
I told you that. I told you that. All right, and that brings us to Mr. Johnson.
Hello, how you doing?
I'm doing fine, thank you. We are on the record in 2024 TR 541, State of Kansas versus Danny Lewis Johnson. County Attorney Jill Gillette for the state. Mr. Johnson appearing in person and in custody and pro se. Now, Mr. Johnson, I just saw you, I believe, last week, and I ordered that you be held for a limited time for contempt of court. And then I understand the military put a hold on you. They were having some problems with you cooperating with picture and prints. Are we past that? Did you get your picture and prints taken?
I did not, ma'am.
Why did you not do that?
Because I didn't feel like it was, I was here for a criminal offense, and there was no jurisdiction for me to get fingerprints and photo, ma'am.
All right, we understand that you need to do that. You're probably not going to get released until you do that.
Okay.
But in any event, you're also here today on a new case, and this is 2024 TR 541. You're charged in count 1 with operating a vehicle while displaying an expired or improper license plate on August 13th of 2024. So apparently before you went into custody, the officer saw you driving, and they may even have that on video if you did it around the courthouse. But in any event, that is a misdemeanor. It's called an unclassified misdemeanor. It carries a fine up to $2,500. It carries a sentence of 30 days up to 6 months. Then in count 2, they're saying that you hadn't registered the car, so you were driving without a legal registration. That also is an unclassified misdemeanor is charged. Another $2,500 possible fine and another possible 30 days to 6 months in jail. Now, Mr. Johnson, I can give you a bond on this, but it looks like you want to just keep sitting there because you can't make bond if you won't.
Your Honor, it is my intent. First of all, I'm not here to frustrate or to disrupt your court or to make anything. Just simply understand. That's all I wanted to understand. As far as the plea, as far as the charge of misdemeanor, I'm trying to understand if that's a criminal or civil offense, but I don't want to get into that today. So it is my regard to ask you, Your Honor, and request in regard to the 8th Amendment that Greenwood Court discharge or administrate a fair fine according to the historical data or registration violation in this county. That's all I ask for now. At this point, I don't want to get into whether it's criminal or whether it's whatever. But according to the 8th Amendment, I just want a fair fine, as if anybody who was driving the vehicle, given I was not driving my vehicle, of course, you held me in contempt. They brought me up and arrested me in contempt. So I don't know how they got me for operating a vehicle.
Well, they apparently saw you do it on your way into court.
Well, what I'm saying is it's a burden of proof on the state for that.
Right.
I'm not going to say they saw me. I don't know what they saw, but right. far as I can notice, when you held me in contempt, they went out and searched my car, which was a violation of my 4th Amendment right. They never issued me a search warrant. They never told me my vehicle was suspected in a crime investigation or any kind of criminal intent or doing anything. So my car was searched. Okay. So when they searched my car, I have multiple witnesses that saw it. When they searched my car, they pulled everything out of my car. And I guess when they didn't find it, then the violation comes. I would never issue a citation for the violation. I was just put on lockdown for the last 7 days.
Well, I think as I understand it, you were put on lockdown because you wouldn't go through booking and processing. They couldn't get you entered into their system.
No,
you refused to get your fingerprints and you refused to get your photograph, and rather than manhandle you and wrestle you and get you to take your pictures and prints, they had to just put you somewhere safe until you would cooperate.
But that wasn't
what I've heard. I don't know that for a fact.
Well, if you look at the video, that is inaccurate. When I came in, I was told I was going to be.
Okay, sir. We'll talk about that just a little bit. Do you need an attorney to represent you on these charges?
I do not. I just want to, like I asked, I'm just requesting that in regards to the 8th Amendment, the Greenwood Court discharge.
That is not going to be addressed today. Today, I need to know if you want an attorney. You're waiving your right to an attorney. You don't want to hire an attorney. You don't want to apply for court appointed?
So what are the fines, Your Honor?
Well, as I said, each one of these counts carries a maximum possible fine up to $2,500.
Okay.
And each one of them carries a possible jail sentence of 30 days to 6 months, although
Okay.
probation is often an option.
Well, I would rather for you to just issue me a fine today. If you issue me a fine, I'll pay the fine.
Well, I cannot guarantee you what your sentence will be. That would be inappropriate to try to give you to negotiate with you and give you a fine before or if you're convicted. Now, maybe if you waived your right to counsel and you wanted to proceed today, I don't know if Ms. Gillette would tell you what her recommendations would be. I'm not bound as a judge to follow the recommendations, but again, typically I do, but I don't have to. Or you can get an attorney that can represent your rights and can help you file these motions or help you weigh your defense and decide how you want to proceed.
Well, all I'm asking you, Your Honor, if you get pulled over and you get a
No,
speeding
we're not
ticket,
going to do that, sir. I just need
all I want to know is the fine. Like normally when you get a ticket or a citation, somebody give you.
I've told you that. I've told you that.
Okay.
So which way do you want to go on that? Do you want an attorney or not?
I do not.
Okay. Do you want to sign a written waiver of attorney?
No, I do not.
All right. But for the record, you do not want an attorney.
I do not.
And no one's making you give up your right to an attorney?
No.
And you understand that you could apply for court appointed if you cannot afford an attorney.
I do not want an attorney. I understand. I do not want an attorney.
All right. I will show on the record, both in the docket note and journal entries, that you do not want an attorney. You've given up any right to an attorney. You intend to represent yourself on these charges. Is that right?
Possibly, yes.
And you were here last week on speeding 82 and a 65 and no insurance. Are you waiving your right to an attorney on those charges in 2024 TR 22 as well?
No, I'll answer that when I go to court on the 27th. I think you scheduled a court hearing for the 27th.
I did, and I am going to set this case today on the 27th at 9 a.m. as well. So both cases will be set September 27th, 2024 at 9 a.m. You've waived your right to attorney, at least on this case. I'd have to review the record to see if you did last week or not. But like you said, we can revisit that at your next court date. Ms. Gillette, in all of that confusion last week, did we set a bond in the other case?
Imagine being able to build an app with your name on it, just by thinking about it. Meet Base 44.
You can check those. If you don't have that handy, I can check the record.
Judge, he had a warrant for failure to appear for $1,000 cash surety. So he actually had.
I paid the $1,000.
Sure.
The cash of $1,000. It is a cash bond that the court is holding of $1,000.
All right. Okay. So that charge, you're free to go anytime you want to, as long as you go through the booking process. You've already, I would consider, even though the jail doesn't show you as being processed because you refuse to cooperate with the processing, which means fingerprints, pictures, signing a bond, I would consider you having satisfied your contempt. I think you've served enough time, far more than I intended for you to. It's been a week now. But you're going to have to go through the booking process. And then I don't know what the military's intention is, but I understand, is it your understanding they have a hold on you, sir?
They always put a hold on everything. Anytime a soldier get picked up, they put a hold for pickup.
Okay. So, and I don't know if they'll go along with, I don't know if it's a game you're playing or what you're doing where you think that you won't have to respond if you won't be booked, but at some point.
No, I'll be here, Your Honor. I mean, even for the 13th, I had to let my command know that I had a court hearing, and I showed up. I'm not a person that want to run from the law. I ain't got time to be running. I face whatever before me, and that's just who I am.
All right.
So I have no. I'm sorry. Go ahead.
No, I'm sorry. You go ahead.
I have no intent of trying to hide from this challenge, because all it is a challenge. You know,
Sure.
I didn't see it going to this extent as being registration violation. If you're gonna give me a registration violation, give me a fine, then I pay the fine, and I'm okay with that. And I had to deal with that from a different aspect. But at the same time, it's just like they gave me a fine for speeding. You gave me a fine to pay, I was gonna pay the fine and just let it be. But at the same time, it's like, okay, now I got a registration with violation. Give me the fine. Give me the fine. I pay the fine. The military picked me up. I deal with that. They don't tow my car. So I really need to get out of here to try, because if I don't get out of here, they're gonna sell my car.
Well, you go and get your picture and prints taken, sign your new bond, and you can go on my counts, on my charges. Now, I don't know, you know, you're still gonna have to deal with.
Well, I know if you release me, the military are gonna pick me up. I understand that.
And are you not wanting to be picked up? Is that why you're refusing?
No. That's the only way I'm gonna get out of here.
All right.
No, I'm not running for nobody.
All right, then you get in there and let that officer get your picture and prints taken. I'm going to order that you do that. And if you don't, then we're going to have to do more.
I ain't got no, if you said I could leave, fingerprint, and that's what I asked them last week. Would I be able to leave if I give y'all fingerprints and photos? They told me no.
Because you've got that military hold.
And I was fine with that, but I was asking about that, Your Honor. I'm not trying to drag this along, but I asked them about that. Is the military going to be allowed to come pick me up? And they told me, no, I won't be able to leave until I come before you. So
you do need to take care of your charges here before you go. That's
okay.
All right.
I will allow them to fingerprint me and take a photo. And if you saying I could be released.
On both cases. Well, you've served your contempt, and that's what I sent you into jail for. Now I'll give you a bond, and you're going to have to post the bond in the new case. Ms. Gillette, any recommendations on that bond? 2 counts of registration.
Judge, they're both unclassified misdemeanors. He's also got some other potential charges for the disruption in court that I am reviewing. And that's the other issue that I've got.
Okay, so there may be another issue, Mr. Johnson, but I'm going to set it at a $500 bond. You can either post cash or work with a bondsman.
I got cash. If I could put it on my card, I got cash.
All right. I don't know what the rules and procedures are, but $500 cash bond. It's 2 counts of registration. I think that's appropriate. And then if you make those 2 bonds and there aren't any other charges against you through Greenwood County, then I will see you in court on the 27th.
Well, man, how would what I don't want to happen is I go out here and post, and then all of a sudden there's another charge. Then I'm stuck here for another 7 days to see you. So I just want to give y'all what y'all need so I can get out of here and have my day in court. That's all I want.
Well, I think an attorney could help you immensely accomplish your goals, but you don't want an attorney to help you, so.
No.
All right. Well,
I just, like I said, I'm okay with doing the fingerprints, doing the photos, paying the $500 bond, and being released to the military.
Okay.
And I guess at that point, I'll see you again on the 27th.
All right. Yeah, I just don't want the military to take you away from me, though, and not let me get you back for a while. That wouldn't be any good, but that's what I told you.
They're not going to do that.
That's what I told you to, and that's what I'm sticking to. But now I can't tell you. If Ms. Gillette has a job to do, and if she has other violations and she charges them, I can't help that. I'll have to call you back in on new charges. But that's what I'm telling you right now concerning the 2 cases I've seen you on.
Okay.
All right. Anything further, Miss Gillette?
Right now.
All right. Anything further, Mr. Johnson?
No, just want to get out of here and go handle my other affairs that I got.
Understood. All right. Thank you, sir. We're in recess as you are being remanded back to the custody of the sheriff. Thank you so much.
Your Honor, what was that first case number besides the 541?
2024 TR 22.
22. Okay, and he's free to go on that one because he paid his bond, right?
He bonded, as I understand it, yes, he bonded on that one. The only reason he was in jail was contempt of court, and he satisfied his contempt of court, so he's free to go on that one, yes.
Okay.
His bond is still active.
All right, sounds good. Thank you.
All right, thank you.
That's smart.
Thank you.
You're welcome. Bye-bye.
Judge Webb is being fair about it.
We are not a traditional cafe. We're completely unconventional. And my Wix website really has to capture the same magic.
I have called your... Ma'am, don't shake your head at me.
Uh-oh.
Let me tell you something that I do every day, 5 days a week. I log on to this Zoom and I know how to manage my courtroom. I'm ready on McNeil.
Judge McNeil is an AG case, just to let the court know.
Ms. Peterson, the charge is trespass, and the prosecutor has informed me that that is also an Attorney General's case. Can you look into this for me? And it's scheduled for pretrial today.
Yes, I can.
All right, I'm going to recall it. Are you able to let me know if you're going to be able to stand in, or if one of your colleagues is going to log in?
Sure, just give me like 2 minutes.
Okay.
Thank you.
All right, thank you. I'm going to put Ms. McNeil back in the waiting room. I mean, ma'am, don't do that. Don't do that, because then I will put you last. Don't act like you're the only case we have here today. Don't act like if you were down at 36th District Court, you wouldn't be sitting waiting. You get the opportunity to wait in the comforts of your own home. So don't do that. We don't do that. But if you have somewhere else to be, feel free to go. You have a court date this morning. You should have blocked off the morning for your court date. Good morning, Mr. Riggs.
Good morning, Judge. How are you?
I'm wonderful, thank you. How are you?
I'm good.
I'm assuming you logged in on the McNeil case?
Yes, ma'am.
All right.
Yeah, she don't play.
And then let me release Miss Peterson on the other case. That person never came back.
Judge Bryan doesn't
Okay,
play.
then I am ready on McNeil and then Garner in that order. All right, this is case number 194560801, the people of the state of Michigan versus Sanita Denise McNeil. The defendant is charged with 1 count of trespass, disassociated person, I think. Yes. And today is the date set for a pretrial. Appearances, please.
Judge, may it please the court. My name is Richmond Riggs, P33863. I am an Assistant Attorney General. I appear on behalf of the people of the state of Michigan.
And Ryan Murad, P83665, on behalf of Ms. Sanetta McNeil, who's present on Zoom this morning. Ms. McNeil, please unmute your device and state your name for the record, ma'am.
Sanetta McNeil.
Your full name, please.
Sanetta Denise McNeil.
Today is the date set for pretrial conference. How are we proceeding?
Judge, if I may, I don't have the file right in front of me, but I believe that the defendant is not a disassociated person. I believe this trespass charge results from prior convictions for assault with a dangerous weapon and fraudulent activity within the casino. And therefore, Michigan Gaming Control Board served her with an exclusion notice that she was not permitted in any of the 3 Detroit casinos.
Okay.
She is not self-excluded. She is excluded by the MGCB.
Thank you, Mr. Riggs. Thank you. Okay. So, Mr. Murad, how are you proceeding?
So, Your Honor, typically I make a motion for dismissal based on the complainant's failure to appear, but it sounds like there's a bit more going on here. What I'm going to ask the
There
court.
is no complainant. What do you mean?
Exactly. So what I'm going to ask the court to do is to adjourn the matter, or maybe set it for final pretrial conference. That way, Mr. Riggs and I can maybe work something out, and I can get the discovery, and we can move from there.
Okay. The court will continue a not guilty plea on behalf of Ms. McNeil. And let me tell you what I found interesting. So earlier when Ms. Peterson was here, and then I asked Ms. Peterson if she was able to, do the case because it was an AG case, and then whatever. And then Ms. McNeil made that face, and then I addressed the face and whatever. Then I didn't even realize at that time that it was scheduled at 8:35, right? So what does that mean? Right. Well, we know what that means. So let me just put on the record what it means. It means that the last time it was scheduled, Ms. McNeil didn't show up. So that is so funny to me that the court did not put a warrant out for her arrest, gave her another opportunity to show up for court, and then she had the nerve to have an attitude because we were trying to figure out who the prosecutor was. Ma'am, don't do that in my courtroom because it won't work out for you. It definitely will not work out for you. Additionally, I try my best to these days, because I haven't always tried my best in this area, to not I don't know, do whatever. But the appropriate way to sit in court is not with your arms folded like that. So that's not the appropriate way to sit in court. And then I'm gonna address bond. I'm gonna address bond at the end of it all, because I keep telling people that me and my staff, we don't come to court for people. I don't know anything about what happened at that casino, right? What I'm doing here is managing a courtroom. Ms. McNeil continues to roll her eyes at me, to huff and puff at me. When I woke up this morning, tired, because I am still drained, right? When I woke up this morning tired, I did not wake up and say, oh, I'm so excited to go to work so that people can roll their eyes at me, smack their lips at me, and treat me as if I arrested them, charged them, and now am presiding over their cases. I come to this job and I try to do my best in this courtroom. But what I won't do is have people who have their own issues come here and bring their issues to me. You have smacked your lips at me several times. You have rolled your eyes at me several times. And the thing of it is, I grew up at 6115 Seneca on the east side of Detroit. I am the queen of eye rolling, the queen of lip smacking, and I'm the queen of some other stuff that my job constrains me from. So let's not go there with me, because I have tried my level best to not only.
Are you still stuffing your kangaroo hoodie pockets? You need the new 340.
Okay, I have tried my level best, but if you roll your eyes at me one more time or smack your lips at me one more time, I am going to revoke your bond, and then we can manage this case while you're in the Wayne County Jail. Don't do that again. You're being rude and disrespectful.
Definitely.
And I have not done anything to you. I have not done anything to you. So if you choose not to come to court appropriately on Zoom, if you have a problem with me saying that you're not supposed to be linked up on the table with your arms folded, let's just come in court in person, and you can stand up at that podium. And then I wouldn't have to worry about you leaning in on that table with your arms folded.
Your Honor, with respect, I'm not even rolling my eyes at you, not even being disrespectful at all
I want you to, that's not how it works. So I don't know what that means, Your Honor, with respect, but also, if If you have something that you want to say, ask if it's okay for you to speak, and then wait to be acknowledged. All right, Mr. Murad, how are we proceeding today? Because as I said, I'm the queen of eye rolling. I know when people are rolling their eyes at me. And I also know I can look at you and see your lips smacking. But here's the thing. We're live on YouTube. That video is still going to be on YouTube. So you, after this court appearance, can go back on YouTube and watch it for yourself. Mr. Murad, I apologize. How are we proceeding?
So, Your Honor, we're asking the court to have the matter set for a final pretrial conference for the purpose of Mr. Riggs providing discovery and hopefully us talking about a potential resolution.
Court is going to set the matter for final pretrial conference August the 24th, 2022 at 9:00 a.m. Discovery should be submitted to the defense by July the 25th, 2022. Bond will continue with absolutely no contact with any Michigan casino. I'm sorry, Detroit. You said she's banned from the Detroit casinos. Okay. So no contact with any Detroit casino. That's the MGM Grand, the I don't even know the casinos anymore.
Greektown,
Motor City, and Greektown and Motor City. Thank you. Oh yeah, Greektown, Motor City, and MGM. No contact with those casinos. Anything further?
Nothing on behalf of the people, Judge.
And Your Honor, just briefly, I wanted to take an opportunity to apologize on behalf of Ms. McNeil and take responsibility for some of this. When I talked to Ms. McNeil in the breakout room, me seeing this at 8:35, seeing a trespass matter, I was under the impression that if the complaining witness wasn't present here, it would be a dismissal. So Ms. McNeil and I really were discussing that course of action. And I think, when she heard the record, she was a bit surprised and maybe exhibited some facial reactions that she shouldn't have. I'd like to take full responsibility for that, Judge. I'm going to talk to Ms. McNeil. We're going to get that together, and that shouldn't ever happen again.
I started putting up this, I started putting this up right here. You all know what I put up. I started putting this up right here when the people were, playing and the court videos on YouTube and putting them on their channel and everything, and I started putting up this right here. The judge that is presiding over the I'm having brain freezes this morning. Johnny Depp, is that his name? Yeah, Johnny Depp and the judge that's presiding over that trial, they don't put anything up like this on their screen. So it's being, like, and so do you know there are like hundreds of memes out and TikToks, it could be thousands, I don't know, of those facial expressions and whatnot that they make in court. Facial expressions are something, right? They're something. And whether or not Ms. McNeil was surprised about that it wasn't going to be dismissed, because certainly I would hope that you would have said it's possible that it could be dismissed, or it's most likely to be dismissed. I would hope that you would have said, but the judge could do whatever she want to do, because the judge can do whatever she want to do, right? So even if that complainant didn't come, the judge can do whatever she want to do within the bounds of the law. That's why when we take a plea, I say, has anybody threatened you or promised you anything? That's why when I take a waiver, I say, has anybody threatened you or promised you anything? Because nobody can promise anybody what I'm going to do, because I'm the only one know what I'm going to do. I'm the only one. So nonetheless, she still shouldn't have been smacking her lips and rolling her eyes, no matter what she was smacking her lips at and rolling her eyes at. Because this is the judicial process, and it is to be reverenced. I know that there's a lot of Zoom courtrooms that make a mockery out of this judicial process, but let me tell you what courtroom is not going to ever make a mockery out of this judicial process, and it is Judge Bryant in courtroom 339. I appreciate that, Mr. Murad, because I was not aware that it was not a disassociated person's case either, or, you know, the trespass usually is a private citizen. Like, that's usually a private citizen. And so sometimes it doesn't work out that way. Nonetheless, I accept your apology on behalf of your client. And of course, we all know that I won't even remember it the next time. All right. Anything further?
Nothing on behalf of the people, Judge.
Nothing further. Thanks again, Judge.
All right. You're welcome. And you're all set. Have a great day. Thank you for logging in, Mr. Riggs. Appreciate it.
Thank you, Judge. Stay safe.
All right. You as well. Miss Neal, remove the hat. Miss Neal, we have been waiting on you all day.
I've been on here.
Miss
since
Neal,
5:30
stop.
this
Don't
morning.
interrupt me. Do not interrupt me. First of all, get off that bed and we don't want to see your legs.
Yes, ma'am. I'm sorry.
Second of all, you came in for a minute this morning and then you have been gone all day.
I've been on here.
Miss Neal. Miss Neal.
Uh-oh.
I'm sorry. Please don't do me like that. I'm sorry.
Miss Neal, you have been gone all day. I have called your, ma'am, don't shake your head at me. Let me tell you something that I do every day, 5 days a week. I log on to this Zoom and I know how to manage my courtroom. I see everyone who is in the waiting room. I see them when they come in and I see them when they go out.
Hi, I'm Andy Levian, General Counsel at the DNC. We just sued President Trump and Doge, and I hope
you were in the waiting room briefly this morning. I have called your case, I don't know how many times, and you have not been here. Everyone who was in the waiting room has already been to the breakout room, has already spoken to the lawyers. I have finished my docket with the exception of 2 cases, and I am getting ready to start a trial. So do not tell me that you have been in my waiting room. You have not. I have asked on numerous occasions, where is Miss Neal? She was here for a minute. She's not here. The prosecutor who was on your case has been dismissed since 10:15. They've been gone since 10:15. Why? Because Miss Neal was not here. Mr. Murad, I am going to send Miss Neal to a breakout room. However, the prosecutor is gone. We will not be handling Miss Neal's case today, and she's in danger of having her bond increased. So you all talk, no ma'am, don't lean up on that counter like that. No ma'am.
Miss Neal, just sit back.
No ma'am, stand back up. And Mr. Murad has muted you because he's trying to prevent you from going to jail. So let's listen to this. Mr. Murad has muted you. We cannot hear what you're saying. Now, he muted you because he's trying to prevent you from going to jail. But let me be clear about this right here. I am Judge Lanice Bryant. Whatever you have to say to me, you better change your tone and change your facial expressions. Whatever you have to say to me, whatever you think you have to say to me, you better change your tone and change your facial expressions. Because of the people that are on this screen, there's only one that's in danger of going to jail, and that would be you. Number 2, when I put you in the breakout room, please take that opportunity to go change your shirt. White t-shirts are not allowed in court. Ma'am, I'm not going to do this.
Can I just do a quick breakout room with her? I think
I'm not going to do it. I'm not going to do it. She's going to stand back too far, and we're going to see those shorts that she also has on, which are not appropriate for court. However, since we're on Zoom, as long as she's appropriate from the top up, then we don't care about the fact that she has on shorts for court because it's on Zoom. So I'll put her in a breakout room. I clearly see that she's in need of one. And
Thank
when you go into the breakout room, please explain to Miss Neal who Judge Bryant is. I'm ready on price before you go deal with Miss Neal. I'm ready for the people who came to court and stayed in court appropriately.
Yes, Your Honor.
I agree with her.
All right, this is case number 076591101. This is the people versus Terica April, January maybe, Neal. Defendant is charged with one count of gambling. Today was the date set for a pretrial conference. Appearance, please.
For the record, Your Honor, Janice Stevenson appearing on behalf of Ms. Terica Neal. Ms. Neal, ma'am, please unmute and tell the judge your full name.
Terica April Janae Neal.
Today was the date set for pretrial. The prosecutor was present. The prosecutor was released at 10 o'clock. As I previously stated, Ms. Neal was present for a minute and left and came back at the end of the docket. Court is going to adjourn the matter. What day am I giving? Judge, we are at July 6th. July 6th. Same time. What time she said? 8:25. Be on time and stay.
Yes, ma'am. Thank you.
Thank you.
Yeah, these judges don't play when it comes to dress code. Even Judge Middleton will tell you, take off your hat. Because it's disrespectful. If you're wearing shorts in a Zoom meeting with Judge Middleton, he'll tell you, you know, these judges don't play. But being disrespectful in a court is not a good thing. I don't recommend it. I don't recommend it. I can't believe these people actually get away with this crap, but you know. I got some sovereign citizen morons too, you know. People that don't know how to act respectful in court. I can't believe it. When I had to go to court for something, when I had to represent the people who owned this building at one time, I was respectful in court. I dressed appropriately, and I acted appropriately. Yeah, exactly, Trin. Exactly. So I'm going to go ahead and call this one for today, guys. Tomorrow is our landlord-tenant docket. Let me check something before we go. Make sure that it's working. Yeah, this whole thing with I just want to check and make sure this is working. Sometimes when you put links, okay, so it is working. So the PayPal link is working. If anybody wants to donate a little bit, wants to donate to help out the channel, I do have a PayPal link. I don't have a cell phone that allows me to put the Cash app on my phone and do it that way. So you can make donations to the channel through PayPal. I do accept PayPal. It's in the main, when you go to the main channel, it'll say, when you go to the channel, you'll see the link. Excuse me. When you go to the main channel, if you pull up the channel, you'll see it. It'll say PayPal. So that link does work if you want to donate. People want to donate and help to the channel. Because like I said, it's $100 for the internet and then $44.95. So I'm paying about $145 a month just to keep this stream going out of my pocket. And I don't want to do a gift send go, because I don't want to do a gift send go and then be accused of grifting or taking the money. If you, it's like I said, I don't have a cell phone to do the Cash app. I don't have an Android phone. I just have a flip phone. And I don't think I can do it with that flip phone. I know I can't do it with the flip phone. I think you have to have an Android phone to do it. You know, taking into consideration that that's $145 a month. It comes out of my pocket. Plus all the work that I'm doing to build this channel up. I've been non-stop. Do you guys realize that I've been non-stop since I've started this channel? Non-stop. Making sure videos are uploaded, doing live streams, trying to build this, trying to find that little thing that makes this channel something. You know, John and Gail said something to me during the week and said that they actually enjoy the content that's on this channel with no drama. That's sad. How do you scam yourself? That's kind of funny. Yeah, I scam myself every day when I come on here and do this. But people are enjoying the content. I get, every once in a while, get messages in the chat or get messages in you know, that are enjoying the new content. I'd rather do this than talk about drama. Yes, drama brought people to the channel and made the channel grow, but I'm not going to do that. And it's out of respect for myself, but it's also out of respect for John and Michelle, which I actually don't have anything against them. I really don't pay attention to I listen to what is said about it, but it goes in one ear and out the other. Every once in a while, I'll listen to the two fleas, but they lie so much. They keep lying so much, I'm afraid that the capacitors on the motherboard are going to break. Yeah, it is. I had to. I thought who is that judge is out of Fulton County, Georgia? Boy, they were tough. I can't think of that name. I can't think of her. I'll have to look it up. I'll have to do a search. I have to do a search later. Because there was that other judge, they were out of Fulton County, Georgia, and would tell them, don't come back to Fulton County, don't even get gas in Fulton County. And like I said, there's nobody banned on this channel. I unbanned everybody that was on the channel. I just don't think that that's appropriate. If you can't act, you know what? We need to pay. I want to say this before I go. That we need to bury the hatchet. This petty shit that happened before, you know, needs to stop. Everybody is welcome on this channel as long as they behave themselves. And I think that this petty shit that went on, okay, yes, maybe I said some things, but the way it was handled was wrong. If you still want to be mad at me, be mad at me, but you're always welcome to come here. You know, I'm not going to ban people because of what happened. I just don't think that that's necessary. If you act like respectable adults, if you can't act like let's put it this way, if you can't act like a respectable adult, then yes, I will ban you or the mods will ban you. But everybody's welcome here. I want everybody to come here, and I want them to learn about the courts and the court system and how it works. Okay, I will look that up. Yeah, they're tough. Tough. Let me write that down. Okay, I wrote it down. I'll probably forget, but I wrote it down. You know, well, it's, you know, yeah, I think, yeah, she doesn't play. She doesn't play. I'm sure I can get a bunch of stuff with her. Judge Gesser is getting hard to get stuff from. I can get a lot of court content, but unfortunately I would have to download it, which means I have to pay for YouTube Premium. And I just don't think it's worth the money. It's just more money out of my pocket. You know, I caught myself watching a couple of their shows, and you know, let them talk about. If they want to talk about what the hells, then let them talk about what the hell. I have nothing against them. What you do on your show is your business. I rather talk about courts and court cases. The only one that's actually allowed right now to come on as a host or as a guest is Rooster Lady. I like her. I love her to death. I think the time there's such a big time difference between the United States and where she is that it's probably midnight or 1 o'clock in the morning her time, or it's real early in the morning. But I have a lot of respect for her. I have respect for, let me say this. I have respect for everybody that comes on here that's with me every day. I'm on here every day doing what I do because I want this channel to grow. If it means killing myself in the process of doing it, I will do it. I tell you what, I am not lazy. I do a lot of research just to get court stuff. I do a lot of stuff for this channel. I do a lot of stuff for this channel. A lot of stuff for this channel. And if it, I love Mercy too. She's been the one that's been encouraging me to keep doing this. Yeah, exactly. If you want to act a fool, you need to take it somewhere else. Because all the mods have been notified what to do, you know. And as far as I know, there's nobody's been banned from the channel that I know of. The last time I looked, the banned users list or the hidden users list was still empty. And I don't think we haven't had any problem. It's been, I started on May 10th, so we figure May, June, July, August, September, and this is almost October. So it's been 4 months, 5 months that I've been on here since I've come back. And we haven't had any problems. I said my piece about it. And then after a lot of consideration through the months, I think it was like 3 months. It was the beginning of this month. I decided that I figured, why am I banning these people? And I decided not to ban them. I cleared that list. Now, Eric and Spawn Trooper are approved users on this channel. And they're always going to be welcome here. Eric is always welcome here. I'm really, it makes me happy to know that Eric knows the legal process involving what happened with him. And he knows his rights. I think everybody should know your rights. And it was something over a misunderstanding. From what I understand with Eric's thing, that it was a misunderstanding. It went too far. From what I understand, and maybe I'm seeing this wrong, if Eric would come on here and correct me, he's always welcome to. But from what I understand, the way I heard it, it was a misunderstanding. It was a misunderstanding that led to all this. And yes, I'm there for Eric. I am subscribed to his channel. That's right. And everybody should do the same thing, Trin. If you know your rights, you should stand your ground. I think, in my opinion, I think the police overstepped their boundaries, especially handcuffing a little girl. That was wrong. I agree with that. The cops blew it completely out of control. I believe that. And handcuffing a little girl, that's just wrong. That little girl didn't do anything. His daughter didn't do anything wrong. But what happened to him in court is just an example of sometimes I would say this, the court system is not exactly perfect. The court system is flawed to the max. There's a lot of things that lack in the courts. Yeah, exactly, Trin. Exactly. And every time I sit here and listen to or broadcast court cases, I think of Eric. That his knowledge and the knowledge of his rights, and then stood up for it. I commend Eric. Yes, Eric got a little heated, but he has every right to be. You know, it's just yeah. I mean, you get criminals that get locked up and then they're out the next day. But I just don't know anymore. But like I said, I'm on Eric's channel. I'm subscribed to his channel, and I support his channel by being there when he goes live. If it's 12 o'clock in the morning here, I'll still be on his live stream watching him. I do support Eric. I'm not going to say their names, but the thing is, and another thing too, is somebody pretending to be a lawyer and sending out a cease and desist to the wrong person. They doxed the wrong person thinking it was me and put out a cease and desist. And that person, I feel sorry for him because that person has no idea what the hell they're talking about. But it's like I said, if that's the way they feel about me, then if I would have known that before, I would have never helped them. And just remember, everybody, ladies and gentlemen, $250 from this channel went to support them. Why would I say anything bad about these people? Why would I say anything bad about somebody that I actually contributed money from the channel? It doesn't. But supposedly I said something, but see, the thing is, if I said something in a live stream, I probably meant it, and there was a reason for it. And I'm not going to apologize all the way 100% for it. I'm not going to apologize for. And what's his name? Instead of being mad, why don't you come back here, sir, and I'm not gonna mention his name. Don't mention it, Trin. Yeah, exactly, Trin. Sir, you are welcome to come back here. I know you're from a different country and everything, but if you want to learn, this is the place. If you want to learn about the American justice system, the courts and the judges in the cases that are before these judges, I would suggest coming on here and just watching, and you're going to learn something from it. What we present on this channel is real court cases with real judges. What we show on this channel is real court cases before real judges with real judgments. Even landlord-tenant law. You need to know if you're a tenant in an apartment building or anywhere that you have a lease, you need to know your rights. And you also need to know what your lease says. If the lease says that you have to pay your rent on the first of the month, we have until the 5th of the month here. We have until the 5th of the month. Normally I pay my rent on the 3rd when I get my 3rd check. So I pay my rent on time every month. If there's something that needs to be, I keep having to explain this because some people just don't understand. If you're paying rent to an apartment complex and maintenance needs to be performed and it's not being done, don't stop paying your rent. Pay your rent on time. Because when you pay your rent on time, you have them. Because that lease, it's like I've said many, many times, your lease agreement is what the landlord expects from you, but it also writes out the terms of what the landlord is expected to do for you. But you should know your rights. If you're in a HUD project, you can go, I think you can still go to HUD.gov, and I know you can pick up that, I know you can get that publication, multifamily rights and your rights and responsibilities pamphlet that HUD puts out to all the Section 8 housing projects. If you don't have it, I have it here. I'd be glad to send it to you. I have a copy of it. I never got rid of it. It's the Multi-Housing Rights and Responsibility, MHRR, Multi-Housing Rights and Responsibilities. I do have that pamphlet. And I do have it in PDF. So I can send it to somebody if they don't have it. But like I said, these are real cases for real judges and real judgments. And that's how you learn the American justice system. Even though it is fucked up at times. I do admit that. That's right. Not only are they giving them the upper hand, Trin, they can get you for non-payment of rent. If there's a dispute, you need to take it up with the landlord. If there's a problem that stuff is not being done in your apartment, you need to take it up with the landlord. You need to go to the rental office and talk to your property manager. I don't have a problem. I can call the office Monday and tell them I need a light bulb change. They'll send the maintenance guy up here with a light bulb and they'll replace the light bulb. It's no big deal. They fix stuff here. But like I said, everybody is welcome here as long as you behave yourselves. And that's just basically the only requirement that I ask. Is you behave yourself. Come in and listen to the stream, even though if you don't talk in the chat, I don't get the watch time hour. I think that is the most fucked up rule I've heard by YouTube. That is the most fucked up rule on YouTube, or the fucked up thing that YouTube did. If there are people watching but not participating in chat, you don't get the watch time hours. I think that's bullshit. I mean, there are live streams I've done on Court. Sometimes they only get 17 views. Some of them get 100 views. I got one that has 200 views. I get 50 views. I got 40 something views on the one I did the other day. If you're the way it should be is if they're actually in the chat, if they're actually on the channel watching, then that should count as watch time hours. If the participants, if they're showing there are participants in the chat or participants on the watching, that should be count as your watch time hours. I have lost a lot of watch time hours. I've lost a whole bunch of watch time hours because of it. I'm losing watch time hours every time I do this because of their stupid little rule. I should have over 600 watch time hours by now. You know, people come in here and want to watch that stuff. Okay, that's fine. But I'm looking at the thing right here, and it says there are 4 people in chat, and only Trin is talking. So I only get the participation from Trin and John when they were in here as watch time. Or I get the participation of Trin because she's been in here the whole time chatting. That's bullshit. It's a bullshit, jacked up thing. I'm going to tell you the exact reason why I got rid of my first YouTube channel. And the very first one I started in 2015. When they changed the rules that you had to have 1,000 subscribers to monetize. That's why I got rid of my first YouTube channel. Because when they made that rule, I was already monetized. I had 250 people on my channel back then. I was monetized and I was making money off of YouTube. Not a lot of money off of YouTube, but I was making something off of YouTube. I don't think they think it's fair, but I don't think, people say it's fair. But I don't think in my opinion, it's not fair to the smaller creators. Yeah, I got 5. I'm watching 5 on my end too. I don't think that monetize 1,000 to monetize or 500 to partial monetize is kind of fair. I don't know how that's fair. Please, somebody explain to me how that's fair to a small creator. How can we build our channel and build everything up and make money off of what we're doing as a small channel if we can't make money off of what we're doing? YouTube has been screwing creators for years. They're giving the bigger channels the more advantage than the smaller channels. Exactly, and that's how I got my money, Trin, by AdSense. I got my money by the watch time and the views and the AdSense. That's how I made money off of YouTube. Every once in a while, I make $100. $100. The first payout for my first YouTube channel was $100. And back then, hey, it's not big money now, but shit, when you're a small creator and you just made $100 on your YouTube content, I wanted to keep doing it. But, you know, they changed the rule. I said, hell, I'm not. Hell, I'm not going to keep doing this for nothing. I'm not going to keep doing this for nothing. Now I got to work twice as hard now because I got rid of a channel that already had 300 subscribers on it. And that's kind of tough to. Somebody's burning food. I can smoke. Jesus, can't these people know you don't have to turn the fucking stove up to heat shit up with these electric stoves? Damn. Yeah, I gave up a channel that had 300 subscribers. I could have fixed it and kept it and just kept going and just started a new thing like doing the court cases on that one. But I felt that my name and my brand were damaged by it. That's why I decided to start new and start out a little bit more knowing. And I think Spawn for that. It was Spawn that brought it to my attention. Yeah, $100 is $100. You know, it's not big money, but you know, it's not big money, but that $100 went towards groceries. You know, I'm not going to argue with it. Yeah, I'm not going to argue with $100 back then. I heard, you know, it's not hard to set up. Doing the PayPal thing, it wasn't hard setting up. I had to delete one of the accounts because I closed the account and totally forgot about it when I went to go get the PayPal link. And I noticed that one of the old accounts that I had linked to it. I had to get rid of it and put my account. But just remember, everybody, please understand, I started this channel on May 10th, and I've been going full force every day. When I was able to do live streams, I've been going full force ever since then. Well, if you think it's a good idea, Trin, to create PayPal, maybe I'll not a PayPal, but if you think it would be okay to set up a Give Send Go, I'll do it. I'll you know, it just. I think I'm gonna. I don't care what anybody says. If you want to support the channel, I will create a Give Send Go, and you can donate money to the Give Send Go to help support the channel. Because I know some people don't have access to PayPal. That was just one of the suggestions from somebody. See, that's the thing. I don't grift. The money that, it's like I said, when that person donated $1,000 for that computer, 500, I don't remember how much it was. I think this computer was $569. I think this computer was $569 with the tax and the shipping and everything. And I showed proof of it. I still have the receipt. I just can't redact it. I can't redact my address. Okay, yeah, I will do a Gibson Go. It's not going to be today or tomorrow. It's probably going to be sometime during the week because I have a live stream. I have live streams that I have to do. Yeah, I sure did. I believe that video is still on here. I don't think I deleted it. I think that the unboxing is still on here. I think I transferred it over when I made a new channel. But that's just about it, I guess, for now. Like I said, when I started this channel, it was just myself, Trin, and my neighbor Carolyn. 3 people. And we're up to 84 people, 84 subscribers now. So I want to thank all the new subscribers to this channel and take this time to welcome you to my channel and welcome you to my platform. Yeah, I saw that too. I was blown. I didn't know anything about it. I made the Gibson Go. I made the video and I posted that I set up everything with the Gibson Go and activated it that night. I went to bed and I woke up and I was watching Skipper. And Skipper said something. Skipper mentioned it on his live stream. I said, no, that can't be right. But I did it and opened up my email. First thing I did was open up my email. And I saw the email from Gibson Go. I said, damn. That's why I left it up for a little bit. But yes, I want to take this time to thank all the new subscribers to this channel. Welcome, 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 welcome to the channel. If you're not a subscriber to this channel and you like the content that's on this channel, please consider subscribing to this channel and helping this channel grow. And I will be setting up a new Gibson Go for the channel. It's just going to take me some time. And I will post the link. I will post a link on the channel when I get that done. So you all have a wonderful evening. I will see you guys tomorrow for the landlord-tenant docket. Ta-ta, ciao, and try and behave yourselves, guys. Don't make me see you guys in court. So you all have a good evening, and I'll see you again tomorrow. Bye-bye.
Come down to it all with your tools in hand, making magic flow. Every broken part, you help me grow. You fix it all, fix it all. You fix it all. Daniel, you make it right. Daniel, everything's right when I'm falling apart. You put me back together. You make it better. From the wires tangled up to the broken dreams. You know how to mend all my scattered seams. With your steady hands, you refill my heart. Every piece that's lost gets a brand new start. clear. You're my solid ground, always drawing near. Never give up on this heart of mine. Put it back together every single time.